And then there's been a motion filed by the filing party, Mr. Wick, for emergency suspension of residential change and motion to modify parenting time that is set forth in that previous decree. Ms. Locke, other than the little recitation that the court has just made regarding history of the case, where are we at this juncture?
The hearing immediately exposes a deeper problem than a routine custody dispute. The real fight is over which court has the authority to make the next move, because whoever controls jurisdiction will likely control the pace and direction of the entire case.
Your Honor, my impression is that Mr. Britt is going to be contesting whether or not Kansas has jurisdiction to enter in any orders about our motion. There's an emergency motion essentially to dismiss the case in Missouri. And I think Mr. Britt's position is that nothing can happen in this case until the court talks to the Missouri case. Obviously, we couldn't have any of that until the order was registered, which is official today because this is the 20th day.
Okay, I can barely hear you, Ms. Locke, so I will need you to speak up.
Sorry. Today's the 20th day that Miss Hilton could have contested registration. That doesn't appear to be her position. So I think the order will be registered in Kansas. We are seeking modification. The children both reside in Kansas. Miss Hilton resides in Texas. There's no reason or any sort of authority for Missouri to continue to exercise jurisdiction in this case. So we will be asking for the court to take up our motion and at the very least stay any execution of the children moving to the state of Michigan until the court can take up our motion.
All right, Mr. Britt, why wouldn't the Kansas court have jurisdiction over custody matters at this juncture?
Yes, Your Honor. So the problem is that the petitioner already filed a modification in Missouri. So we have simultaneous proceedings, and Kansas law is very clear that if there's already a pending modification proceeding in the original state, that Kansas cannot do anything until it's resolved in that original state. Now, in full transparency, I'm involved in that Missouri case. We're arguing that it should get dismissed and it should come over to Kansas. The problem is the Missouri judge has not made a ruling over there at this time. And until they do, to conclude and terminate that, this case can't really move forward because we'll have two cases proceeding simultaneously. And in both cases, the petitioners asked for the exact same relief. So we just want to get the subject matter jurisdiction issue resolved to where we're down to just one case so that we can move forward in the appropriate jurisdiction from there.
At least as far as the UCCJA is concerned, Mr. Britt, wouldn't you concede that Kansas can assert jurisdiction over child custody matters?
If there was not already a pending action in Missouri that was filed prior to this case, I would. And that's what I argued in Missouri.
What's your authority for that assertion?
It's KC 23-37209-3. Well, let me go up. It's in my motion here. Sorry. 23-37206, which provides that a court of this state may not exercise its jurisdiction if at the time of the commencement of the proceeding, a proceeding concerning the custody of the children has been commenced in a court of another state having jurisdiction substantially in conformity with this act, unless the proceeding has been terminated or is stayed by the court of the other state because a court of this state is a more convenient forum. That state, Missouri, has continuing and exclusive jurisdiction under the UCCJA until that is released. I would agree that it should come to Kansas, and I would not be contesting that at all if the petitioner had filed his action in Kansas first. We'd be good. I raised a big stink in Missouri about it being filed in Missouri to begin with. What happened here is what should have happened to begin this entire action. But for whatever reason, he chose to file it in Missouri, and now we're stuck in this chokehold between the two states.
Okay, I'll stop you there, Mr. Britt. Ms. Locke, why did your client proceed in two different states at the same time, creating this jurisdictional mess?
Sure. Your Honor, I wasn't involved in the decision in Missouri. It happened prior to. I believe that was a request for an emergency stay in Missouri, which the court in Missouri could exercise an emergency stay when he received notice of Miss Hilton's intention to move to Michigan. So he received notice of her intention to move to Michigan before the school year was over, and then filed this request for an emergency stay. There was a discussion between attorneys that Missouri really doesn't have any jurisdiction, and so this case needed to be filed in Kansas. I have had conversations with the Missouri attorney. This is proceeding in Kansas, but it wasn't registered in Kansas yet. So the court in Kansas couldn't do anything at all until we registered the order here. So that's the first step, was registration. This is the 20th day since we served her with the notice of registration, allowing the registration to be effective, and now we can move forward. So until this day, when we could start to move forward, we had to continue that Missouri case, which can now be dismissed, and the court can act on the motion to modify. In addition, Judge, the court under this simultaneous proceeding statute can make modifications that the court deems appropriate until that Missouri case is dismissed, which it will be, and it sounds like Mr. Britton is in agreement with that. So it seems a little nonsensical that he would be arguing that today, but here we are.
Yeah, the Missouri attorney is not arguing for that case to be dismissed, and it wasn't an emergency stay. It was another motion to modify that was filed over there, and he was arguing that Missouri still had jurisdiction to be able to move forward, and we both had to file 25, 28-page UCC-JEA briefs on the issue that are on file being reviewed by the judge in Missouri. That they didn't need to file anything in Missouri to register this in Kansas. They could have just registered this in Kansas and moved forward, and we wouldn't be in this issue. He waited until after I filed a very lengthy brief disputing things in Missouri before he finally decided to file something in Kansas.
The discussion gradually shifts from legal theory to litigation strategy. Each attorney presents the history in a way that minimizes responsibility while emphasizing practical necessity. That is common in interstate custody disputes because no lawyer wants to appear responsible for procedural confusion.
Is the Missouri case set for hearing anytime in the near future?
No, what the judge had informed us was that if the issue was just a matter of interpretation of law and all of the factual findings were undisputed, which they are in both briefs, he would just rule on the pleadings, and he has not ruled on those pleadings yet, and it's been a little over a month.
My impression from my conversation with Mr. Wickey's Missouri attorney today is that it is set for review on August 20th. I do have the judge's contact information. As soon as this was occurring, we were working to register the order, which takes a bit of time in addition to finding and serving Miss Hilton. So we have been working on this case to try to get it resolved in Kansas. But then the nature of getting a certified copy, getting it registered here, getting it served, waiting the 20 days, all of that is a little bit of a time-consuming process. But we're here, and the court does have the authority to make modifications pending actually being able to take up our motion to modify.
I am looking
You're
at
relying on what part of the simultaneous proceeding statute?
In a proceeding to modify a child custody determination, this is subsection C. A court of this state shall determine whether a proceeding to enforce the determination has been commenced in another state. If it has been commenced in another state, the court may, in paragraph 3, proceed with the modification under conditions that it considers appropriate.
It wasn't an enforcement that was filed in Missouri, though. It was a modification. And I am looking at it now. I have not received any email notice about a hearing being set, but I've got the Missouri case pulled up since I've entered, and I can confirm it does appear that there is a hearing at 10 a.m. on August 20th.
When does school start in the Texas school district where your client lives, Mr. Britt?
Well, it would be the notice of relocation was going to be to Michigan. So the Michigan school district would start. Christina, can you unmute and let us know when that would be?
Yes, Michigan school starts between the 15th and 20th of August, and I have an appointment set with registration on August 10th.
Judge, that would be
In
inconsistent.
Kansas, Ms. Locke?
Yes, Your Honor. The Kansas school district starts on August 18th. And just for the record, and I did provide exhibits, my understanding of the school district in the town that Miss Hilton gave my client notice of, that district is called Forest Park Schools. And that school does not commence until, yes, much later in August. It looks like school starts maybe August 27th.
You dispute that, Mr. Britt?
I don't have the requisite knowledge to dispute what day it starts.
All right. From just an initial review of the file, it would appear that really what is triggering all of this litigation in these two states is a clause that the parties agreed to back in their original parenting plan order, which essentially said that beginning with this school year, the children would live with and therefore have primary school residency with the mother in whatever school district she resided in at that time. Correct?
Yes.
So it would appear to this court that until at least the first date of actual school attendance, probably there's a little more time that has to pass before a change in custody or a ruling regarding custody has to be issued. Obviously, what the court would want, I think in any state, is for these kids to start the school year in which they're going to finish it. Obviously, the father agreed to something back apparently in 2019, as I understand it. What the rationale was in negotiations that led to this particular school year being chosen as the year that things would perhaps change, I don't know. But the reality is it appears that's what the reading of the parenting plan order would suggest. And the father is obviously not wanting that particular provision enforced. Quite frankly, this court would just rather just sit back and see what the original court does first. I think it is unfortunate that two different proceedings was initiated, and I understand the rationale for that now after Ms. Locke's presentation, but we essentially could have a jurisdictional battle here, or at least some controversy about who's ultimately going to make the decision prior to this, the start of this next school year. Or perhaps it's contemplated by the parties that the decision can be made later. But the kids need to start school somewhere.
Your Honor, there is a triggering date in the 2019 judgment for when the custody exchange would take an effect, and that date was July 1st, so it's already passed.
Well, it obviously didn't take place.
No, the children are with my client right now.
Okay.
And Judge, the summer visitation, although what Mr. Britt is saying is accurate, that the children are with his client, that is consistent with their summer visitation schedule. They spend and have spent summers with mom.
Well, I'm looking under a different.
Once the conversation turns to school calendars, the hearing stops being purely about jurisdiction and starts becoming a race against time. The judge recognizes that every legal argument is meaningless if the children are forced into a last-minute school transition without a clear court order.
Provision in that decree called physical custody beginning July 1, 2026. Mother's home shall be designated as the children's home for educational and mailing purposes. All right, so Ms. Luck, what are you requesting from the court at this time?
Your Honor, we're requesting even under the simultaneous proceeding statute that the court simply stay any change of school until the court can have further hearing on whether it's in the best interest of the children to modify their school district. And in that interim period, we can work on getting the Missouri case either resolved or the courts can have communication, direct communication. And I have the contact information for the judge in Missouri, which is contemplated under the UCCJEA, that the courts would communicate to try to decide which court is better suited to take up the issue.
Well, there's not even a dispute in that regard.
Correct.
If I understand it. From Mr. Britt's presentation earlier, he seemed to concede that Kansas is the better forum to eventually determine the issues in this case, but it's only the fact that there's a pending Missouri motion pending, which is acting as a blockade to this court exercising that jurisdiction.
Yes, Your Honor, and I
Why
would be
does your
happy.
client just dismiss his case in Missouri?
I will encourage him to do so, or at least enter an agreed order to terminate jurisdiction in Missouri. I think that is a very wise decision.
We would be fine with that. I asked his Missouri counsel about dismissing it, and he argued with me that he thought Missouri had jurisdiction, so they wouldn't do it.
Well, there are times under the UCCJEA that more than one state has jurisdiction at the same time. And you have to determine what's the most convenient or what's the best forum for resolution of the then current issues. I ran into this before. But I do note that Kansas is apparently the home state of these children. They've certainly been in Kansas residing primarily here for more than 6 months. But the court's inclined to do, if this wasn't the triggering year, what would the return date be for the children on just traditional summer visitation schedule?
I don't have the judgment in front of me. I got to pull it up.
Your Honor,
I think the parties would know.
yeah, it's typically either the week before school starts or a few days before school starts. The parties have tended to be pretty flexible on that.
Okay, that's been their policy, but is there a specific provision in their parenting plan order that states the exchange time?
Your Honor, the current parenting plan is actually for mom to have the kids every other weekend. So they have essentially completely modified their parenting plan since it was entered and have been following a plan where mom gets school breaks and has gotten summer breaks.
Okay, so there's always been some flexibility on the return date.
Yes.
All right. Mandy, can you bring me my calendar? I'd like to get this matter back before the court before either one of these school start dates. I guess the next question is, what type of hearing is contemplated? Any ruling this court would make regarding the start of school tends to point this case in a direction as to where it might end up. Because once we start a school year, I think both parents would agree that they would hate to disrupt the start of an existing school year. I really don't know what kind of calendar time I have in early August. As far as a full-blown hearing regarding best interest of the child, such as a contested primary custody motion, I don't think I have a date on the calendar prior to the start of school. Well, Mr. Britt, I didn't ask you, and I should have. What do you believe this court's role should be at this point prior to the start of school in these two districts?
Yeah, so at this point, I think the unfortunate reality is this court's kind of stuck until Missouri dismisses it. Once the Missouri case goes away, assuming it will, I would say this court then has the full jurisdiction under the UCCJA to essentially do whatever it wants. It could enter temporary orders, it could enter permanent modification orders. So I don't have an issue with us having a hearing on temporary orders at early August before school starts. If we can get the Missouri case dismissed before then, I can send follow-ups and try to get that push through on my end. If a UCCJA if a contact from this court letting them know that we've got this issue helps get that going. I will say, when we last spoke, in Missouri, the judge had actually called counsel and raised concerns about whether they had subject matter jurisdiction, which is why we had to file these briefs and everything like that. And I have made the court aware that there is a case now here in Kansas. So I'm hopeful that expedites things. But if I can get his Missouri counsel to back me on dismissing that case, I think it would go a long way in letting us move this forward.
Mm-hmm.
A child who starts a school year in one district naturally develops a stronger argument for stability there. That reality changes the leverage of both parents. The court is thinking beyond today's motions and focusing on preventing a rushed decision that could unintentionally determine the outcome before anyone fully presents evidence.
Well, I certainly think Kansas can assert jurisdiction over the children involved in this case at this juncture. First of all, Kansas is the de facto home state at this point. And I think this court could make a finding that at this point, neither the children nor either parent live in the original state. So I believe that it would be very proper for this court to exercise jurisdiction over the issue of child custody. But I think what the court wants to do is to review status of the Missouri case. Wednesday, August 5 was what I'm looking at this time, counsel. Wednesday, August 5. I have some scheduling flexibility.
I will be in a full day trial in way northern Missouri that day.
Well, you have my sympathy, counsel.
It's only a 3-hour drive to that courthouse for me.
Okay. What is your availability on the afternoons of Monday, August 3 or Tuesday, August 4? I might be able to work something in for what I think essentially would be a non-evidentiary, essentially an oral argument hearing.
I could make either of those days work.
Ms. Locke?
Judge, I have a review hearing with Judge Crum at 3:30 on the 4th. Unfortunately, I'll be out of the office on the 3rd for a medical procedure, but I'll be back on the 4th.
Okay.
And that's my only current.
You need to steer away
item.
from 3:30.
Correct.
Yeah, I've got a case management conference in a Missouri county that morning, but those are just like status hearings. It's set for 9. I should be done before noon.
Okay. Well, I was looking at possibly doing this at 2 o'clock that day.
I would be back by then.
All right. And again, it would be by Zoom. There is at least a possibility that this court will be making at least some sort of temporary orders in the case based on then existing circumstances. Until then, I'm not necessarily expecting that there be any change of physical custody. Apparently, the children are fine where they are with the mother at this juncture, and it wouldn't necessarily have been contemplated that they do the exchange by August the 4th anyway, just based on past history. So we'll review the situation of the children and child custody jurisdiction Tuesday, August 4, 2 o'clock p.m. by Zoom. And in fact, I think we can just use the same Zoom numbers, Mandy. And then that way, that make it easier for everyone. August 4, 2 o'clock for status hearing.
Your Honor, if there is a modification on the Missouri side prior to that August 4, would you like us to let the court know in advance of the hearing date?
What
Like,
exactly would be coming from the Missouri court?
If the case is dismissed in Missouri or Missouri enters an order that they're not going to exercise jurisdiction, would you like us
Yes,
to
this
give
court would
you?
want to know,
Okay,
as would obviously opposing counsel if only one attorney got notice of that. And Mr. Britt, you're actually an attorney of record in that case, are you not?
Yes, I am. So as soon as I see something like that come through, I'll send it over right away.
All right, thank you. All right, Mr. Britt, anything further at this time then?
Not at this time, Your Honor.
Ms. Locke?
no, Your Honor.
All right. Hopefully we'll all just go forward from here with the idea of the best interest of the kids in mind.
Thank you.
Thank you, Judge.
We'll see you August 4th at 2 o'clock by Zoom. There's nothing further.
Your Honor, may Mr. Britt and I stay on the hearing momentarily? Okay.
Yes, we'll leave that open for that purpose. Okay. The court will leave the meeting at this time and we'll stop recording and broadcasting.
The judge's questions reveal a preference for solving problems instead of escalating them. Rather than rushing to exercise authority simply because Kansas appears to qualify, he openly considers whether allowing the Missouri court to finish its jurisdiction review might produce a cleaner legal path. That restraint is significant. Judges often have the power to act, but experienced judges also know when using that power too quickly creates unnecessary appeals or conflicting orders. His repeated focus on communication between courts reflects an effort to reduce chaos instead of adding to it. The discussion becomes less about winning a procedural battle and more about building a decision that will survive future legal challenges without creating another round of interstate conflict. As the hearing continues, the judge begins separating legal authority from practical reality. Even if Kansas ultimately controls the case, he understands that forcing immediate changes without resolving the remaining procedural questions could create greater instability for the children. That balanced approach keeps both attorneys engaged because neither side receives the sweeping victory it hoped for. Instead, the judge signals that cooperation may accomplish more than aggressive litigation. The lawyers also begin sounding less confrontational and more solution-oriented, recognizing that continued procedural warfare benefits no one. By steering the discussion toward workable next steps instead of legal posturing, the court subtly shifts the incentive from fighting over technicalities to clearing the path for an informed custody decision.